Welcome to Appointed.
It's another incredible privilege to be speaking with the Honourable Harry Laforme. I've known you for many, many years, and I thank you for the incredible ways in which you have promoted justice. Doesn't seem to even do justice to it, but the way in which you have been committed to not just the interests of Indigenous people and First Nations, Métis, and Inuit people, but the ways in which you have insisted on injustices of all kinds being remedied for all people, not only those who suffer the most dire injustices and colonial and violence. And you have joined us before. I'm very pleased that you're back with us, and I want to thank you very much for the work that all of the work you've done all of your life, but in particular, your most recent work on miscarriages of justice and the work you did with the Honourable Juanita Westmoreland-Traoré in terms of the Miscarriages of Justice report, the recommendations you made that, in my humble opinion, should have been followed. They were thoughtful, well-considered, incredibly well-researched, and you knew what you were, what needed to happen, and it is really beyond unfortunate. It is, I think, a travesty that the government has not chosen to follow through. And as we know, they have introduced a bill. It's entitled Bill C-40, and supposedly the Miscarriages of Justice bill that came as a result of, and is characterized as a result of your report, but fails to pick up some of the most crucial aspects, in my humble opinion, fails to pick up some of the most crucial aspects of your report. And I wonder if you could talk a bit about the process that you and Justice Westmoreland-Traoré, how you looked at these issues. You interviewed an incredible number of people internationally, as well as folks here in Canada who have experienced miscarriages of justice, and talk a bit about who you spoke to, what you recommended versus what's in Bill C-40. I think it would be incredibly important for people to hear, and we will include in the notes that go along with this podcast the report, of course, as well as the bill, and some of the briefs that have been put forth, and including the one that you were part of, as well as our contribution, which was as a result of the work that you asked me to participate in as part of that miscarriages of justice, and led to the injustices and miscarriages of justice experienced by 12 Indigenous women report that we put out. So over to you.
Okay. Well, I can honestly say it was, first of all, I think it's important to know we tabled the report on my birthday, actually, October 31st, 2001. It doesn't seem that long ago, does it? I mean, it was, time flies, I guess, when you're having fun, but it wasn't fun reading the bill that came out of it, because I think about the only thing they did were a couple of suggestions that we made. They didn't even get the name right that we proposed. One of the things we learned very early on, and I want to tell you, we had 45 roundtables over a summer, and it was in the time of COVID, as you know, so we had to do these things with roundtables, and we had 215 people, 17 survivors of wrongful conviction. We received 45 different submissions. We interviewed with some people from Australia. We had commissions, all 5 different criminal review commissions that exist. They come from the UK, Scotland, New Zealand, which was the most recent, one from North Carolina, of all places, and I think there's a couple more, I don't know, but I can't recall them all now. And we just had a flurry of activities. One of the things that I think that I want to tell everybody is that we started our consultation process with exonerees. I think there were 15 of them or something like that, and they were the most, it was the most insightful, incredible, and moving experience that I personally had. And I think I can speak for everyone who participated in that from our end, that they really set the tone for what we were looking for. At the end of it, we decided that we weren't going to be shy about what we could recommend. We wanted to recommend something that we believed was all-encompassing, that it really tackled wrongful convictions. And those interviews we had with those people, they contributed to that. They contributed to our mindset, our passion for the project, if you will. And it's something that I still have. I mean, I thought I had it before, but these people, including David Milgaard, I think we were one of the last groups to talk to David, and your 12 women, that was incredible. They helped us, I think, set the tone for what we wanted. And instead of trying to tell government what we thought we could get away with, what we thought we could ultimately end up with, was a little bit different than what we actually did. We went out and said, what would the commission look like that was real, that really tackled this issue? Because it's horrible. This issue is really, really far more incredible than people think it is, and it's far more disastrous to people's lives. I mean, as an example, our Criminal Conviction Review Commission currently, I think they do, in the last 20 years, I think had one remedy a year out of 85 up at the time of our report that they considered applications. And you put that together with what Scotland does, and they have 1/7 the population, and theirs is, I forget what it is, but it's thousands that they get. And they've had 800 plus suggested remedies that they proposed over that same period. Canada is addressing one a year. I mean, that's just fundamentally wrong. And one of the things that we decided through the process was that we wanted a commission that would be proactive, that would go out there and tell people what we were, what we're about, that there is hope, if you will, on the horizon. Because I can't understand why Canada, over a 20-year period, gets 85 applications. Why? Why only 85? And we know there are thousands that are wrongfully convicted that are sitting there. So we wanted a commission that would go out and say, we're here. We want to help. You know, we want to correct this injustice. And so that's how we started. And I have to tell you, I was encouraged by the minister at the time, David Lametti. I really believe, and I still believe, that this was a concern of his, that this did interest him and that he really wanted to. But I think in the end, he was a politician and he was working with government, and he was concluding that we can't do all these things. I don't know why they can't do it. I don't know government that well, but what we were asking for, and I think what I'm going to tell you is some of the things, they can happen. They can happen very quickly, and they can happen correctly. And nobody has a downside to it other than people who prosecute these things. And, you know, if mistakes are made, it was a fair trial. Good. You know, you've been convicted by a fair trial. And we know that that's not true. Thousands of them are sitting in prison right now as we speak because of this. So that was our process. I think one of the questions you were asking me was, what are are some of the shortcomings that we had, or one of the obstacles in our research. And I can tell you that I don't think that was a problem, Kim. I think ultimately the problem came afterwards. You know, when our submissions and our consultation report, which is about 212 pages, and it's a good read. It's not something that everybody's going to fall asleep to when they read it. They're going to read it and they're going to say, wow, I never knew this, or wow, this is easy, or we should do this. I just think so. I don't know if you ever heard, have you heard about a professor in Auckland who did a study of our submissions, of our report? Her name was Leonetti. And one of the things that she said was that, if I can just find it here, that our bill would be, here it is. She says that if our report, hopefully the Canadian government will seize this singular opportunity to implement a monument to justice and place Canada as the global leader in addressing wrongful convictions. It is a detailed blueprint for a transformative CCRC. And I believe that. I believe it was. Mm-hmm. And that's not what we got. When I went to the committee, for example, they gave me 5 minutes. And I don't even think I was invited originally. I had to almost force myself on the agenda. And I would think that if anybody was going to get time to talk about what the bill should say, it would have been us. It would have been either me or Justice Traoré. And we got 5 minutes, if you can understand that. And then I got cut off because I couldn't get it out in enough time. And everybody went on their merry way. And that's how our bill became, that's how we got a bill C-40. Yeah. Anyways, that's my introduction to it. It's pitiful, really.
Yeah, it is pitiful, and it lacks so much of the, as you've mentioned, the incredible research and work that you and Justice Traoré did, because you, as you mentioned, you talked to exonerees, you talked to people who are waiting, like the 12 women who, didn't trust, even as you remember, to have any of the justice folks involved, because their experiences of injustice are so profound that they trusted the two of you to speak with them, and then that gave them great hope moving forward. And when you recommended that I write up their stories and we did the report, each one of them routinely asked me for new copies, and they provide it to other people to try and show, look, there are some people who recognize I shouldn't be here. And but so far, as you know, only Odelia and Narissa accusants, has there been agreement. And since your report, when you pointed out that, or since your review, when you pointed out that only 20 cases had been reviewed, and all of them were men, and only one was an Indigenous man, only one a Black man, then they've tried to step up. But it's been now more than 2 years of them reviewing Narissa and Odelia's cases, and it's fraught because they're still sitting waiting. And so anything they do, like wanting to go see family, is a breach of their bail conditions, and they're struggling to, until such time as they're reviewed, and for behavior that would never be criminalized if they weren't already criminalized and wrongfully convicted. So, I'm extremely concerned that our governments, and I say governments because no matter the political stripe for the last 20, 30 years, they have not taken progressive approaches. And we've seen it with child welfare, we've seen it in this area, that it's almost like the people who have the least, who are most disenfranchised and most subject to these bad laws have to find the resources to fight. And only once they've fought and succeeded, then there's some kind of recompense. And it's such a colossal waste of time and money and human resources, not to mention fiscal resources.
It's also the case, Kim, that it's not only costly, it's time consuming. It's absolutely time consuming. When you try to take this on as a wrongful conviction, for instance, it eats up your life and a good piece of your life. Look at the exonerees that have happened. They've only been fighting for 10, 20, 30 years, some of them.
Mm-hmm.
I mean, this is an incredible waste of human resources and money. And the money has to come from people like Innocence Projects, which do this for nothing.
Mm-hmm.
Incredible.
Yeah. And
the public doesn't, I don't know what I can do or what I have to do to charge the public up that can make this. I would have thought the report, had it was published and everything, it gets published over the Justice website, but big deal. Whoever goes to that thing, and then people don't get charged up about this. They get charged up about maximum minimums or minimum maximums or whatever they call them. And that's what they do. They law and order. They're into law and order because that's what they get told. They get told that crime is rampant and we gotta get tough on crime and everything. And it's not. I mean, that's not really what's happening out there. This is happening and it's real, and people are dying in prison who shouldn't even be there.
Mm-hmm. And in fact, and people are in denial about that it's almost like it's okay to criminalize people. And once they're criminalized, then it doesn't matter what the true story is, you just pile on. And, I was reminded of this in our recent budget. They claimed they were going after auto theft. We actually talked to car manufacturers and found out that they could actually provide the mechanisms that would help eliminate the auto theft issue. But they're not doing it. And instead of us mandating that the car companies have to do that, we're putting in place Fagan provisions and provisions that will actually result in more people, predominantly poor and racialized people, ending up in prison. And so
that's what C-40 will do. It isn't going to help. I can tell you right now, it's not going to help.
Right. What amendments do you think, if any, could be made to C-40 that would actually help make that happen?
One of the first things I would say is they could, now I don't know if anything has been amended since it began, but if you look at section 696.5, subsection 1, and compare that to 696.6, subsection 1, one talks about investigations, how the commission, the new commission, goes about it. And it said it can investigate if reasonable grounds to believe a miscarriage of justice may have occurred, and that's a good thing, or it says, or in the interests of justice. Then the following clause that I read is about remedies. This is what the commission can provide as a remedy if they find reasonable grounds to conclude miscarriage of justice may have occurred, and that's the word, and it is in the interests of justice. That's an inconsistency that is really troublesome in my view. First of all, I think interest of justice should go, because it's just so vague and it lends itself to all kinds of interpretations. I saw it as a judge. I can imagine it as a judge, and I can imagine lawyers, the arguments they can make. But one is you can't investigate unless you have both, and you can remedy only if you have one or both. One is one or the other, and the other is both. Now, how does that work? I mean, that's just crazy. One of the other ones, I mean, you can start with the commission, the commissioners themselves. We wanted the most the people that were most captured in all of this and that are the subjects of over-policing and over-incarceration. I mean, we're talking about where 35% or more of the inmate population of federal institutions are Indigenous. Can you imagine? We make up 1% from First Nations of the population. 5% of the overall population are Indigenous people, and yet we make up 35 or more percent. It's worse for women. I understand. I know that is over 50%, if I'm not mistaken.
That's correct.
And black people are almost as bad. I mean, I don't know what their percentage is, but they're incredibly overrepresented in prisons. And we said, if you're going to have a commission, could you at least have commissioners that are Black and Indigenous? Because they're the ones that are, as I said, are most susceptible to this over incarceration. And they didn't. What they do is they provide a provision whereby you have to consider. That's all. You have to consider the diversity, especially including Indigenous and Black persons. Well, you can still end up with a commission that doesn't have anybody, and they have 4 to 8, including one commissioner. We would have liked the chief commissioner, and I think there are people out there who are more than capable, the chief commissioner or whatever they're going to call it, to be Indigenous or a Black person, because there's a thing about judicial thinking that we constantly talk about, and we say, and I know this is real because I did it myself, and I know that it happens, that diversity is about your lived experience informing your decision making. Well, that's exactly what we want here. And I know I did that as a judge. I allowed my lived experience. You can't help it. It just informs your decisions. And it goes back to what when I was appointed to the Court of Appeal as the first Indigenous person ever. And I only sat there for 14 years without another appointment anywhere in Canada. But Justice Irwin Cotler, Minister of Justice at the time, and I thought he captured it absolutely beautifully. I said to him, why me? Why did you pick me? And he said, Harry, who better than somebody who has lived their life with injustice knows the meaning of justice? And I mean, that was beautiful. And it was so right. And it applies here. Like if you understand what I think this should be appointments by an independent body. They did that with the Truth and Reconciliation Commission. So I know they can do it. They put together a body of people, of experts or whatever, and they say, give us a list of people who should be commissioners and give us a list of who you think should be the chief commissioner. And they do that. But that's not what's going to happen here. The governor and council is going to be able to do this, and they're going to use their wisdom. A lot of old white guys are going to sit down and decide who's best for any of this. And I'm sorry, it doesn't work, Kim. It won't work. And they reduce the number of commissioners. We thought 9 should be a minimum. They say, 1 full-time and a minimum of 4, and then maybe 8. You can have a maximum of 8. We know Scotland, for example, is 1/7 the population, or New Zealand, 1/7 the population, and they're inundated. They can't go with the commissioners they have. And these are only part-time commissioners. There's only 1 full-time commissioner here, and that's the chief commissioner. So it's a recipe for disaster right from the beginning. And I know people like Mr. Lockyer think that it's a new day and that there's hope for this. And maybe if they do everything right, it can improve the situation. But it doesn't. It's not the answer, Kim. Improving on this is not the answer. We provided the answer. We wanted, as I said, a proactive commission that went out there and told them, we're here to help. And then we have the mechanisms to help. But they don't want that. They didn't want that. They wanted control over it, and they've got it. They've got it.
Well, and you went even further because what struck me is even the existing innocence projects and incredible work that's being done by incredible people out there also had missed the injustices that you and Justice Traoré insisted on looking at when we talked about the 12 Indigenous women. The fact that so many women in particular take responsibility because of familial, cultural, community feelings of responsibility, and that their ability to be heard is so much more limited even than many of the men, that it's not surprising that even the innocence projects and the conviction review projects that exist across the country haven't actually assisted many of them. And yet you drilled down and said, we need to have these kinds of issues explored. We need to have the possibility of looking at sentencing reform and look at mandatory minimum penalties, as well as the conviction reviews, because all of that piles on to create the kinds of injustices that you were reviewing. And and I know we've already talked about this a bit, but why do you think these essential perspectives were ignored? How is it that we end up with a bill C-40 that, some see as incremental steps forward? I agree. I actually see it as a way to actually continue the injustices, because if you provide a wholly inadequate model, then the injustices continue, and people just throw up their hands and say, "Oh well, it's just there's nothing we can do."
I think that's right, and I think this is a body that has the capacity to exacerbate the problem. It's not unaddressed. It's possible, I suppose, if everything is perfect, but it already is possible that you could do more and do all these other things and whatnot. But that's not what this new commission was supposed to do. It was supposed to be an answer to the problem. It was supposed to be an independent body that was going to be able to look at this. What's independent when the government controls everything from the appointment of commissioners on down to the budget? And the budget, we said, and I know this is true because this was a complaint of every commission we talked to. When you talk about constraints on budgets for government, one of the first things they look at is something like this: projects like miscarriage of justice or commission review, conviction review. They cut, like how many times the UK talked about their budget being cut, and it's just minuscule now of what it should be. It can't do anything really. And they control everything. We wanted a budget, and we wanted the budget consideration of the commission done by an independent body. They were going to assess whether the budget was adequate or not, or whether they were overspending, whatever. It was going to be done by an independent body, and then it was going to make recommendations to government that way. That's what we wanted. The same thing with the commissioners. We wanted them, an independent body, to say, these are the people that should be the commissioners. And we never got any of it, nothing. And that's how you make this ineffective, is by having this total control. And you have to think about it as it's part of a colonial system that protects itself. That's what it does. And that's what you're getting here. You're getting a colonial system that Indigenous people and Black people and all the others that suffer through this have to live by and live under. And that's what gives them their authority. And they like that. They're not going to give this authority away, and they don't. They gave it to the TRC because in the end, the TRC didn't really matter, did it? I mean, it mattered to all of us that read it and were participating in it, but it didn't matter to government. They've got 94 calls to action in the report. And how many of them have been implemented the way they should? The Yellowstone Institute says none.
Yeah. Well, and the calls for justice of the missing and murdered Indigenous women and
Yeah,
girls inquiry is another example.
another example.
Yeah,
It's
and
a colonial system in its colonial structure, and it's there to protect itself, and it's there to maintain the controls that they're used to controlling and they want to control. That's all. They're not going to give it to us.
mhm. Well, and it struck me by naming it David and Joyce Milgaard's law after they're both dead,
Yeah,
and in a context where certainly my discussions over decades with David would, this would not have been what he wanted to see. He recognized, I mean, the number of conversations he and I had about how there was no end of resources to build more prisons, put more people in prison, hire more prison guards,
yeah,
and yet there were always constraints on how do we actually provide for clean water in communities, ensure that kids have education, have care, keep kids together in their families. All of those issues take a back burner. But the minute we want more money for law and order, so-called law and order, which
yeah,
really I talk about as more laws, less order, and it really results in the continued mass incarceration of the most marginalized and the people who every other system fails, and not that we don't see the questioning of these. And you know, you've been at this longer than I have, and what do you think it will take to get, I mean, we're going to put in the notes for this, all of the information you've talked about, the paper that
yeah.
was done in New Zealand about your recommendations, your recommendations themselves, our reports. But what do you think it would take for the public? I think when the public hears these stories, they are enraged, like us. They see the
For
travesties,
how
they
long,
understand them.
Kim? For
Yeah.
how long? Do they stay enraged until they get a new thing to worry about? Like, oh, I don't know, uh, a spike in crime, and all of a sudden we got to go out and we got more mandatory minimums, right?
Mm.
And they do nothing except all of the people that get captured in this in our study, and all of the people that you've talked to and everything, they just have more and more reasons to go to prison. That's all that does, and for a longer period of time.
Hmm.
And that's all. And it doesn't give, I mean, that's so much for judicial independence. Originally, when I started out as a judge, used to say, trial judge, they said, how do you sentence people? Well, you sentence for the offense and the offender. That's what you do. You take that into account. And then you can fashion a sentence. But now you're not even allowed to do that. Now it says, who cares what the offender is? Who cares if they're first time? Who cares what their circumstances are? If they're guilty, they get 2 years. You
Hmm.
got to give them 2 years. That's crazy.
Hmm. What do you think it would take to bring the public's attention to this so that we don't continue to see these kinds of miscarriages of justice, that we don't continue to see the proliferation of ineffective, not just ineffective, but dangerous approaches that actually result in more people spending longer periods of time in prison, coming out with less? I mean, a lot of folks think people go to prison, they get most people
No,
assume, including judges, that they're going to prison, that they're getting treatment programs, all the rest of it to assist them to get out. You and I both know that's not true. They go
that's
in.
not.
At best, they come out the same as they went in. At worst, many come out with many more issues and more, certainly mental health issues and the like, as well as, no access to jobs, a criminal record, and inability to move on with their lives. So, what do you think it would take to get the public to see this? Does it mean the government has to take leadership? Does
Yeah,
it mean,
I think the government does have to take leadership, and they have to. Everybody has to be talking about this. The government, in its entirety, has to be talking about it, starting with the guy that's at the top, who doesn't seem to want to talk about anything. But he's the guy that should be talking about it and leading all the troops and making it an issue. You know, if we could, as you say, Kim, and I think it's correct, if you told these people, I would like to see these exonerees and your 12 women. I would like to see them go out and talk to the public, because they'd be all crying. The public would be crying. They'd feel so bad about what we do to people, what we as a society do to others of society. We just abuse them over and over, and we don't care. One of the things about our justice system is that it's through errors of what we do. And we don't like to admit we've made errors. And the system is designed for that reason. I mean, all the rules that you have as an appellate court judge, I can think about some of the rules, and it is deference to the trial judge, deference, 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 over and over again. And what the trial judge's findings are, you have to leave them alone. They were there, they say. They know best. They looked in the person's eyes. They know when they're lying. Well, they don't. Because even if one of the reports said, even if we take a minuscule number, like say 0.5%, even if we said they're wrong and we were able to establish that, that's still hundreds of people that are wrongfully convicted every year. Hundreds. That's 5% or 0.5%. That's incredible. I think for the public, and it's got to be the public, unless the public gets behind this and says, do this because we don't, it's got to be cost. It's crazy how much, like the Quezon sisters, I don't know how much we've spent keeping them incarcerated. You know, if they would have just sat there by themselves, did nothing for 7 years, they would be out of prison for committing murder. They'd be out of prison. But they didn't. Every time they did something wrong, every time they got out of line a little bit, administratively, whatever, 35 years in prison for a murder. I mean, nobody does that. But they did. And that's what we got to, people have to know that the cost of what we're doing is astronomical. When we do this, when we wrongfully convict people and we incarcerate them and keep them there for decades, it costs more than letting them out. They can helping them find a job, for crying out loud. Do you know that exonerees get nothing after 30 years when they're out of prison? They get sent on their merry way. Thank you, sorry, tap on the behind. There you go. And people, when they get paroled, they have supposedly programs available. I know that none of it's adequate or anything like that, but they have them. They have some kind of assistance for these people. But exonerees get nothing except the invitation to come fight us in court if you think we owe you anything. That's all. That's all they get. And people, I think if people know that, if people know that that's the truth of the matter, that keeping people in prison is costing you way more than rehabilitation or proper rehabilitation, then I think they might care. But I mean, I would have thought a long time ago that when you say 35% of the prison population is Indigenous men and more for women, over 50%, I would have thought the public would go crazy. They haven't. They haven't.
No,
and I don't know.
True.
I don't know what it takes. We have to find ways. And I'm looking. I did this report, and I hoped that people would consider it seriously. They haven't. I know that now. There's nothing in that report. For example, how do you do you collect evidence if you're the commission, if you're this commission? How do you collect evidence? How do you force them to give you evidence? There's nothing in this bill that makes that do that. You cannot force people to turn over evidence if they don't want to. Privilege. I have privilege here. And if you want to test this privilege, you got to fight me for it in court. You know, that shouldn't be. It should be like a law society. You should be able to go out there, gather anything you want in terms of evidence, and you be responsible for privilege. You can do that. They've done that. The government has done that, but they don't do it in this bill. And
So that's
we know for a fact that the prosecutorial services don't want that. They don't want this commission to have that kind of authority, because I guess they don't want their mistakes shown. I'd love to apply that in a place like Saskatchewan, for example.
absolutely.
I couldn't imagine how many of those were wrongful convictions. And this happens all the time. We have people, and I'm dealing with this through a complaint, and maybe we'll talk about this later, Kim. But I've started a process. 4 years now I've been at it, of Crown attorneys up north who are racist, and we know that's true because we've been told that's true by the courts. We've been told that's true by the Justice Department. Indigenous people face racism, and it's systemic throughout the entire criminal justice system, from top to bottom. So these Crown attorneys giving their racist attitudes, we reported them to the Law Society, right? And for the first time, one of them is going to have a hearing before a panel of benchers for discipline purposes, because he's racist towards Indigenous people. That's the first time it's ever happened. And it only took me 4 years to get there.
Wow.
I know.
No, that's exactly that's one of the things that has shocked me. It's not just the people who are overtly racist. It's the people who are really excel in their field.
Yeah.
A number of really good criminal lawyers that I know, who, when they discover that their interpretation was wrong because it was racist or misogynist, or their inability to own those mistakes is also part of the problem, I think.
Yeah.
Because, as you know, there were people involved in some of the cases of these 12 women who thought they were doing a really good job of arguing a particular point, whether it was 718(2)(e), otherwise known as Gladue factors, or it was, not sending women to P4W because they're Indigenous, and never examining the whole context in which, how were they here in the first place? And so missing entirely the wrongful conviction component of it, because they were, more fixated on what the evidence was and how it had been collected, and not questioning whether there could have been a misinterpretation from the get-go, whether it was from the police, the Crown, any of those, and not because of, there's the intentional or the clearly racist, individualized racist decisions, but then there's these systemic that are born in some part out of ignorance, that people just don't understand the context. And I think of that or
they just grow up in this colonial system. This is it. This is our justice system, so it's got to be right. It's got to be right, and they think it's right all the time. Oh, every once in a while they make a mistake, but they're human. It's not once in a while. I'm sorry.
No, and it's really good people sometimes. So I use Narissa and Odelia Cuisance because they're now public. I mean, there are many lawyers who looked at their case, including some of the ones involved now in their conviction review, who did not see the racism and the links to why they said they were responsible. If you don't understand familial, cultural, community responsibility, that they felt responsible because their younger cousin had killed someone, so they took on that responsibility because that was part of how they were raised, to believe that they were responsible. That gets interpreted as legal responsibility when it has nothing to do with legal responsibility. And so they're, even people involved in reviewing their case initially, it took a long time to say, look, you're not thinking this through in the ways that they interpreted this, that you have equated personal, moral, ethical, cultural responsibility to legal responsibility. That does not mean that they did the killing. That means that they were there, that they
they weren't responsible for the killing.
That's right.
I mean, why do you think it took 4 years to convince the Law Society that there was actually racism going on here? They had to be educated. Now, fortunately, we were able to do that, and I think it'll maybe make a change in the laws. I don't know. Whoever knows
Yeah.
what these things are, but I mean, it took appeals, and we over and over, and letters, and how to address this and what to look for. I mean, the Law Society originally, in the case of this Crown attorney I'm talking about, didn't even want to look at it because it was a Ministry of the Attorney General problem. It wasn't, because they worked for the Ministry of the Attorney General. It wasn't the Law Society's problem. They didn't even understand their own rules of conduct, which is to regulate lawyers, and Crown attorneys are lawyers. But I mean, you have to go through almost a year of convincing them that, and appeals to the commissioner of the Law Society. I mean, that's what it took. And fortunately, I'm retired now. I can do these things. I'm never going to retire, I know.
No, and you're tenacious, and you're insisting
Yes.
on the miscarriages of justice being corrected. And for
That's
that,
right.
I and so many others am and will continue to be eternally grateful for that. And I want to thank you for all of this work, and for pointing out the shortcomings of Bill C-40, because we need to, as you know, it's now come to us at the Senate. It's being sponsored in the Senate by Senator Arnott, who's a former judge as well, from Saskatchewan. And I'm hoping that we will be able to make the amendments that are required to actually make it effective. And
I hope so.
one of the keys you've already mentioned, and I want to underscore, is the commissioners have to be representative of those who are coming before the system in order to have some understanding of the miscarriages of justice. So I'm hoping that you and Justice Traoré are the first two to be appointed, and then and that we see some changes that require at least half of the commissioners to be those who are otherwise not represented.
You make a good point, and I have to comment on this, but I didn't realize that at the beginning of this process, they wanted me to have somebody from Quebec as part of it, and I accepted that. I didn't know any French, as you know, and so they appointed Juanita, and I have to call her that because she insisted on it. And when I met her, I was absolutely floored, because her attitude, her approach, her passion for these issues was like-minded with me, and I just had so much respect, and I loved everything about working with her on this project. And she was one of these people that said, yeah, that's it. We don't have to do what we think is possible, that the government will do. We have to think what's the possibilities of the best. And that was lovely. And I'll work with her any day. A Black judge, a female. This is absolutely perfect.
Well, that seems like the best place for us to leave this and say the work is not finished yet. And
far from it.
And all of you listening to this podcast, I hope that you will tune in and make your views known to your elected officials and to the senators who are going to be considering this bill, that these amendments need to be made to Bill C-40 so that it can actually be a bill that addresses miscarriages of justice, not a bill that reinforces and creates new miscarriages of justice. So thank you again, Justice Laforme, for joining us, and and thank you for your life's work.
I always have time for you, Senator. Thank you.
Anything we didn't cover, Nicola, that you want to?
Yes, I'm going to mute you so there's no feedback. There's actually one thing I would love to hear you speak to possibly put. Can you hear me okay? I think I might be having.
No, I can hear you.
Okay, fantastic. One question I have that might be useful to insert at some point into this podcast for listeners is there's no legal definition of a miscarriage of justice in the criminal code, and it was a kind of it was the subject of conversation for the testimony and evidence before the House of Commons committee for this bill as well. And so I would actually love to hear what you believe to be a definition of the miscarriage of justice. I think many people's conceptions of it only land on someone being innocent in every single regard and a judge making a very erroneous mistake and putting someone innocent. But it also should include systemic issues and factors as well as over-sentencing. So I would love to hear you speak a little bit about the definition.
Well, first of all, let me say, you make a good point. I mean, we made at this point in our report as well, that this commission should have the ability to examine and accept systemic issues of whatever they might be, which, and for Indigenous people and Black people, they're all over the place. You know, the whole systemic issue was something that we wanted the commission to be looked at. It doesn't have that authority, or at least yet it's going to take somebody brave that designs this mandate to do that. And I think a miscarriage of justice, personally, is anything that results, in our case, in a wrongful conviction or a misapplication of, for whatever reason, somebody goes to prison for, like the Quezon sisters. There's no way they should have spent 30 plus years in prison. There's no way. There's a problem there. Something is happening, and somebody is conjuring up reasons why they have to stay there, and somebody has to be able to look at that. The other thing that I'll tell you, which I disapprove of, is that the wrongful conviction aspect has to have, in order to establish it, has to exhaust all rights of appeal. That's impossible. There are so many people in prison. All you have to do is think of that Dr. Smith case and Professor Kent's book on wrongful convictions, where he talks about imagined crimes. Well, these women went to prison pleading guilty to an offense that didn't happen. There wasn't an offense there. None whatsoever. It was all because of this madman's idea of what should be a crime, or what they did should be a crime. So they were in prison. There's a lot of examples of that too, where there's imagined crimes where these people just didn't commit them, and they're in prison. And some of these people, like 2 years in prison for, I mean, we know a man, and we interviewed him, and he was part of our group. He spent over 2 years in prison, and he was supposed to have killed one of his children, and they threatened him with deportation if there wasn't a guilty plea. This guy had a choice. He could either stay in Canada and live with and provide for his family, or he could get deported and let them provide on their own. And I mean, this is crazy when we do things like this. That's miscarriage of justice. Anything that results in people wrongfully convicted, I don't care whether it's law, a breach of law, or whether it's just a breach of your common sense. There's a problem with that. And that's got to be, and that's why we wanted in the commission, to be able to assess systemic issues that apply in Black communities and in Indigenous communities. And Kim, you know too well what some of those are for Indigenous communities. You've heard it over and over again.
Mm-hmm. Yeah, no, thank you for that. And thank you, Nicola, for reminding us, and that, you know, that whole area of the lack of definition leaves it wide open to be a very narrow definition, which is in fact what the bill points to, is the narrowest of definitions of miscarriages of justice, because of, as you mentioned at the outset, the need to have both aspects of the provisions there, that there's been a miscarriage of justice and that it somehow reflects poorly on the system. And the fact that we don't allow for it to, from my perspective, it underscores the racism and misogyny and the discriminatory aspects of the existing law when you have a new law brought in supposedly to correct the miscarriages of justice that actually replicates, allows for the replication of those miscarriages by not taking into account situations where people have been induced to plead guilty because of their feelings of responsibility. I mean, the example you used of the man facing deportation if he didn't plead guilty to killing his child. The number of women who Dr. Smith, they already felt guilty because they were single moms and their children had died, and they had already internalized a responsibility for that, and that just gets capitalized. And, I remember talking to some of those women and them saying, well, I guess it was my fault. Of course I should have done everything possible. And I often use the example with when Tammy Marquardt and I have presented together of, she'd said, it happened to me, it could happen to you. And I said, not a chance. As a non-Indigenous, as a white woman who had degrees, including a law degree, my son had some of the same issues your son had. But if I had called emergency, as you did, and I couldn't remember how to do CPR, and I was panicking, and my child was having an asthma attack, was caught up in the sheets, and I couldn't figure out what to do, I can guarantee you when the paramedics arrived, if my son was dead, they would not have assumed I killed him. They would not have made that automatic assumption. That it's only when you think, okay, this is an Indigenous woman who's on social assistance, whose child has, there's already been child welfare involvement, that somehow you could be more likely to have killed your child. And those racist, misogynist assumptions and classist assumptions always come into play. And
one thing I need to mention here, in Indigenous communities up north, there's a different principle of law enforcement that goes on up there than anywhere else. And you take a woman, and I know this for a fact because it was an actual case, that part of our complaint to the Law Society. She is Cree, she's middle-aged, 5 children, street person, knows very little English, went into I think a store or something, used her, I guess they have to have cards now for welfare cards or get food or something like this. And she didn't have identification on her. So she was denied. And she grabs the card back and scratches the lady when she's doing this. She went to court on about 12 or 13 different offenses arising out of that experience. And she pled guilty.
yeah.
And the judge, to her credit, said, if this was a white woman, you wouldn't be doing this.
Yeah.
To the Crown. Yep. That's actually there. That actually happened. And that happens all the time. So you can't tell me, I mean, I think she had an offense, but probably had a defense for the original offense that gave rise to all these other things flowing out of it. But she didn't know what to do. And how many of those would she be able to say, I was wrongfully convicted of those? About 12 out of the 13, I would say.
Yeah.
So that's how it works.
I have one last follow-up question, if that's all right.
Sure.
In your report, you speak about the capacity, giving the capacity to the Commission to compile evidence, compile data, and try to make recommendations to stop miscarriages of justice. If the Commission was given this power to use the information that they get before the Commission of miscarriages to try to prevent them, what would be your anticipated and or your best case situation of what changes could be made to prevent miscarriages of justice going forward?
You want me to answer? I would think a lot of what we were just talking about, Kim, you talked a lot about these Indigenous women that you met and whatnot, is to try to understand. I would hope that the Commission, and I have to tell you, I wouldn't want to give this authority over to the current makeup of the Commission. or what they're going to do under the new rules of this commission, because I don't have much hope for that. That's still government controlled. It's still going to be part of government. It's still all these. I don't even think they can hire their own staff. I don't know, but they'll probably get bureaucrats that'll work for them. But when you do that, when you try and articulate these systemic issues, what they really are, and apply them to the justice system, it's going to be a hard fit, because justice is really crude. It's made up of sharp edges that, they dictate what goes on in a courtroom, and it's really difficult for any human aspect to it. You almost have to go to a tribunal system whereby you can actually consider these things. It's a blunt instrument to dispense justice, I think, and a lot of that's going to change. But all you have to do, but I think you can really identify the problems and make that available to judges, and try to apply it that way. But it's not going to work when you have mandatory minimums and things like that, where a judge doesn't have any room to use discretion or his common sense. So I don't know, Kim, can you add on to that?
Well, and I do think that one of the things this commission could be recommending, as much as you have, is to actually address the issue of mandatory minimum penalties and the ways in which they create miscarriages, or they create the context that feeds miscarriages of justice. Because, and going back to the review that Justice Lynn Ratushny did of the cases of women who were jailed for defending themselves. One of the first things she said is she, at the time, now we're talking about almost 30 years ago now, at the time she didn't feel she could go behind the guilty pleas because the evidence of the abuse was available in many cases at the time that the women were being tried, but the judges didn't know about it because the Crown may have known about it, the defense may have known about it, but it was not seen as relevant to the actions of the woman because of the misogynist ways, the ways that the defenses of self-defense and defense of other were built up around the way the law attaches and interacts with men, and was around men fighting versus women trying to fight for their lives. And so, anybody who picks up a weapon is automatically seen as more culpable than someone who doesn't have a weapon. Whereas we know that most women, if they engage in hand-to-hand combat as they're in the midst of being beaten up, are likely to end up dead. And so they grab a knife, a pan, whatever is available to try and defend themselves. And then they get convicted of an offense with a weapon. And so they look more culpable.
That sounds like a bit like the Quezon sisters. Anyways.
Yeah.
I think everybody knows my views on that.
and many of these women.
Yes.
Yeah.
Yep.
Yeah. And so as far back as 1996, Justice Ratushny was saying, if we really want to address these issues for women in particular, and more particularly Indigenous women, we have to look at the context, and we have to look at mandatory minimum.
And how far have we gotten in 30 years? Yeah.
It's worse.
Yeah, it's worse. Over 50% of the prison population in women's prisons are Indigenous women, and they make up 5% of the population of Canada. Well, half of that they make up.
Yeah,
and they make up over half the population of prisons. That's crazy.
And it's worse for young women, as you know, in Saskatchewan, Manitoba, in the north, Indigenous young women are 95 to 100% of the prison population. And so the trajectory is just getting worse. And so,
it is.
And it's interesting that some, students like Nicola and others who have done incredible work, law students who work in the office, some of them who precede this current cohort of interns took the courses in justice, miscarriages of justice courses at university, and their profs, most of whom are male, have said things like these cases aren't true miscarriages of justice. Now, those are taught by white men. And, the fact that they don't understand the situation that these cases outline, I think underscores the need for the kind of commission that you and Justice Traoré have recommended, which is, that can do the kind of systemic analysis and has the very people who understand some of these contexts and can bring that analysis to their work. So thank you, Nicola, for raising the issue of the definition, as well as the need to, how do we look at the context and how do we actually design a commission and through Bill C-40 amend that bill so that it actually provides for a mechanism that will actually resolve, not exacerbate, wrongful convictions and miscarriages of justice. So thank you again for Nicola for organizing us, and thank you, Justice Laforme, Harry, for your incredible work and your ongoing work to address these issues.
Thank you, Kim. And thank you for yours. Mutual Admiration Society here. Okay. Thank you, Nicola.